All rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. This is Arizona Court of Appeals, cause number CACV130011. Ariano versus Primerica. Good morning and welcome to the Court of Appeals. For your information, these proceedings are being recorded, both audio and visually. So with any luck, you will have your 20 minutes of fame on YouTube in a couple weeks. As you approach the podium, please identify yourself and who you are representing. Each side will have 20 minutes to present their briefs or present their arguments. Appellant, you may reserve a portion of your time for rebuttal, and if you'll tell us how much time you want to reserve, we'll try not to horn in on that time, okay? We've read the briefs and we've discussed the case in conference this morning, so we are familiar with the facts and the legal issues. And with that, you may begin.
May it please the court, my name is John Egbert. I represent the defendants and appellants in this appeal. As the court's aware, there are three primary issues addressed in the briefs, the first of which involves the exclusion of the applications for the policy. I'm going to start with that issue because I believe that's one that if the court agrees with our position that the statute does not apply here under the facts of this case, then the result of that would be a reversal of the judgment and a remand for a new trial, and really the other issues then would not need to be addressed. This is a de novo review, so no deference the trial court's decision is not entitled to any deference. The statute at issue here is 20-1108A, and that statute says that no application is admissible in a case, or shall be admissible in evidence, and this is the critical language, in any action relative to such policy. So an application for a policy is not admissible in an action on that policy, unless the application, of course, is attached to that policy when it's issued and delivered. That statute does not make inadmissible all applications for any and all actions. Instead, it only excludes the application for the policy that is at issue in the litigation. That is why this statute doesn't apply here, because the policy at issue in this litigation is the alleged oral promise of completely unconditional coverage, which the plaintiff alleges the agent made to her. So it's that oral promise that is the policy at issue in this litigation. The applications that were submitted and which Judge Buttrick excluded were not submitted for that policy. They were submitted for the policy, which is undisputed, was never issued and delivered in this litigation. So on the language itself of that statute, it's inapplicable for that reason. But even further reasons, it just doesn't even make sense to apply in this context where the insured dies before the policy that was applied for was issued and delivered. Because
so counsel, your argument is that the oral policy bears no relationship to the at least the second application involving the agent Donald, someone. There's no relationship to that at all.
No, Your Honor, I don't think it's fair to say that there's no relationship. Obviously, it arose out of and has some connection with that process.
The agent had delivered a copy of that application to Mrs. Ariano before he left her home. Would that have satisfied the statute?
Well, if you buy into the concept that an oral promise can be issued and delivered, as those terms are used in Arizona's case law, which we've cited in our brief, then I guess that would be possible but I don't think that's a possible interpretation of what that language in the statute means, to issue and deliver an oral statement. And then you go on to the next problem of how do you then attach or make part of that application to that oral statement, alleged oral statement by the agent.
Don't you give them a copy of it? I think that's how you attach it. You provide them a copy of it. You have this oral agreement that you give me a check and you are temporarily covered. And, I understand that you've got arguments in terms of whether the application is accurate and those kinds of things. But in essence, isn't it, I give you a check, I give you, the insurance company, a check that you cash, and if I'm given a copy of the policy or a copy of the application, at least as you're reviewing it, I can go through and I can say, oh, you transposed the birth dates. I didn't, we didn't sign the application that, or our name is spelled wrong, that kind of thing. But that's how you attach it, wouldn't it?
Well, Your Honor, I don't believe so. I don't believe that this statute has any, it has no application in the context where the insured dies before the actual policy is issued and delivered. That's what this statute is going to. And you're right that there is, the underlying rationale for this statute is that if the insurance company is going to rely on and say that the application is part of that policy, and they're going to rely on any representations made therein, that when and that's what the statute specifically says, when that policy is issued and delivered, then you need to make sure, the insurance company needs to make sure that it's attached for that very reason, so they can look it over.
But I don't see anywhere in the statute where there's an exclusion for these oral agreements or oral insurance policies. It doesn't say only when the insurance company has finished doing their investigation into the applicant does this statute apply. It just says no application for the issuance of a life or disability insurance or contract shall be admissible in any action relative to such policy or contract unless it's attached. I don't see any exclusion there.
Well, Your Honor, I would cite the court to the only case that either side was able to find that addresses a similar statute. And we in our footnote, we cited there's at least 17 states that have virtually identical statutes. One of those states is New Jersey. And in the Manzo decision, they had the same argument, where they said that attached to the conditional receipt should have been the application. And the trial court bought that argument and said, yeah, that seems to be right. You should attach it to the conditional receipt. The appellate courts rejected it and said, no, the statute that we're dealing with doesn't say you have to attach it to the conditional receipt, doesn't say that doesn't say any of those other things other than that the policy for which it was submitted, which is the ultimate policy, which wasn't, in this case, either issued or delivered. So they interpreted, the only case that that's ever been decided that either side could find rejects that notion that there's no exclusion for oral promises or for the conditional receipt, the preliminary, the temporary coverage. There they ruled just the opposite. They said that the statute only says it has to be attached to the policy for which the application was submitted. And nobody went to Mrs. Arellano and said, here's an application for an oral promise. Please fill this out, and then you'll have unconditional coverage. That's not what happened here. And so we submit that the statute doesn't apply here for that reason. And it also leads to absurd results. Because one other thing I want to point out, too, is that there's the policy or the concept that you have to fill out an application and then immediately give them a copy of that in order for them to check what they just told you in that session, that's a different concept. What is that reasonable? Is that necessary? As opposed to later on when the policy is issued in a final form.
To me, though, that the insurance company would want to know that that information is accurate before they issue a policy. And if you're taking information from them and it's not accurate, and you issue a policy based on the fact that it's not accurate, that seems backwards to me. It seems to me that you would want that information to be absolutely accurate before you issue the policy, so that you can say, you know, you've got these conditions, we're going to put in these exclusions, or whatever. That just seems backwards to me. I'm sorry.
Yeah, well, Your Honor, the other problem, I think, with that conclusion is that it does create an opportunity for insurance fraud with impunity. Because then if in the situation where you have someone who submits makes misrepresentations in an application, they could do that, and then if the insured individual dies before there is the policy is issued or delivered, then the insurance company is going to be in a position like Primerica found itself here, of not being able to respond to or demonstrate the misrepresentation. And if they are fast enough to where they do reject the policy based on the misrepresentation, then the individual simply needs to go make a new application. Whichever insurance company happens to be in the process of underwriting at that time is going to be stuck with the coverage and not be able to defend based on the misrepresentation. We think that's bad policy, and the legislature should not have been intending that to be the result here. I failed to ask for 5 minutes of time, and I beg the court's indulgence to do that now. I do have a few more minutes, and I'd like to spend some time addressing the punitive damage aspect as well, because that's a very significant issue in this case as well. In this case, again, the review is de novo. The appellees have all but ignored the controlling case law from this court, including Nardelli, which is a insurance bad faith decision itself. And in each of those three most recent decisions, the ratio was reduced down from something shy of 10-to-1 in the trial court to just a 1-to-1 by this court, including in Nardelli, where the trial court had itself reduced it to a 4-to-1 ratio. And even then, this court said that's not low enough to satisfy the constitutional provisions, and therefore was reduced to 1-to-1.
Counsel, just occurred to me that they have a cross appeal, so if you want to reserve a little bit more of your time to address their cross appeal, because they're going to get the last word.
Okay. I think 5 minutes should be sufficient.
Okay.
Thank you. So, with respect to the three guideposts, and by the way, the appellees want to change those guideposts and say, well, really what really matters here is deterrence and punishment. And that's not what the guideposts say. The guideposts, in fact, the Supreme Court says just the opposite. The Supreme Court says that, quote, the wealth of a defendant cannot justify an otherwise unconstitutional punitive damage award. So the constitutional analysis is separate and apart from the deterrence and punishment aspects that the other side wants to emphasize. In terms of the three guideposts which are supposed to be considered, it's clear that that all of those factors, with the possible exception of the vulnerability of the individual, weigh heavily in favor of that this was at the low end of the reprehensibility scale.
You don't think that forging an insurance document is reprehensible, isn't reprehensible?
No, Your Honor, here the trial court specifically found that he was not going to instruct the jury on the punitive, or with respect to punitive damages on the so-called tort of forgery, precisely because there was no evidence of a malicious motive in that action. So what the trial court judge who's sitting through and seeing all this, even he says, look, there's no indication that these signatures were done for any reason other than to move the policy forward so that Mrs. Arellano would have the very policy which she's relying on and wanted to have the benefit of.
Except to reduce the amount of coverage.
Yeah, and that was something that there's very little evidence about what that was all about, and nobody ever pressed that argument after when the claim was made, that Primerica never tried to suggest that it was for a lesser amount. So here, in terms of what was presented to the jury, there was no evidence that even that forgery aspect, so-called tort of forgery, was a reprehensible conduct. Now, they try to say that there were other things that make it reprehensible, like gee, it was undisputed that the agent promised unconditional coverage. Well, it wasn't undisputed, and they repeat that over and over in their briefing, and we quote from the trial testimony, Donald's testimony, where he did dispute that. He was asked point blank, did you promise unconditional? No, I did not. And what did you say? And then he describes what he said, and there are two ifs and the word conditional in his description. That's not an unconditional promise. It's not undisputed. And many of their arguments in terms of reprehensibility with respect to punitive damages are built on that false assertion that it was undisputed. I would like to save the remainder of my time for rebuttal.
Thank you. Counsel, before you get started, since you have a cross appeal, you will have the final word. So if you would like to reserve a portion of your time for your rebuttal on your cross appeal, you may do so.
Thank you, Your Honor. Charles Onifrey from Schneider & Onifrey on behalf of the plaintiff appellee. I would request 2 minutes on the reply on the cross appeal. Your Honor, my comments really are not going to track the brief so much. I want to get down to the brass tacks of our position. The court's asked plenty of questions about that first issue regarding the admissibility of the application. The question that I pose is, would it have made any difference in this case if the application came in? Let's assume, just for the sake of discussion, that the jury would have concluded to believe Donald, who had lied about a variety of things, about it being conditional, over Miriam, who said it was unconditional. Let's just assume the jury could have and did reach that conclusion. They still have to prove that they're entitled to rescind the policy, essentially, under ARS 2011-09. They have never disputed that that is the standard by which statements in an application are judged as to whether they're going to be a basis to rescind the policy. And they not only don't dispute it, they don't address it. And quite frankly, the failure to address that is very telling, because I think it says they have absolutely no response to ARS 2011-09. Well, why is that? Well, the statute specifically says that, well, you need 4 things. First, they got to show that it's a false statement. But under the statute, they have to show that it's a fraudulent statement, material, and that the policy wouldn't have been issued had they known the true facts. Let's just go to the very last element of that. Number 3, they have no offer of proof from any witness who would have said, if I had known that about the EKG, I would have never issued the policy. They never identified a witness to that effect. They never made an offer of proof to that effect.
Counsel, what was the effect, the legal impact of the receipt of 2 premium payments from the Arianos at the issuance of both the $100,000 and $150,000 policies? This is a contract arrangement that gives rise to questions of consideration, correct?
Well, in our view,
What were they buying for their premium payments?
Well, of course, Mrs. Ariano thought that she was buying insurance until she was told otherwise.
Did she get the money back?
Not until after the claim was denied.
And after the claim was denied, after she made her claim for the $150,000?
Correct. After they had conducted whatever investigation they claimed to have done, they decided they were going to deny the benefit and return the $106, I believe. But throughout the entire time, they retained the premium, and hence one of the reasons why she reasonably believed, and Donald agreed, she reasonably believed that she was entitled to coverage. I met with the agent. We went over the application. I gave him my money. He told me I had coverage. I never heard back from him again. That's the case, plain and simple.
What else did she need to comply with in order to fully, to comply? with the requisites of obtaining that coverage. What had she not done?
There's nothing she had not done. I know that the Primerica claims she didn't do things. In their denial letter, they said, well, certain tests were not obtained. Well, they didn't ask for the tests. Number one, they said that the application had been withdrawn. Well,
Mr. Ariano did not speak English.
correct. Or if he did, it was his preferred language was Spanish.
And they took his word during a telephone conversation for the fact that he wanted to rescind the policy?
Right. He, not being the owner of the policy, they took his word that, or not his word, his interpretation of that conversation that he was withdrawing the policy.
The conversation held entirely in English.
No. I believe.
I thought that Daniel was an English speaker.
No,
Oh,
it was
excuse
no.
me. Excuse me. Mr. Ariano spoke in English to the best of his ability to do so. Is that
No,
what-
he
Right.
spoke
I
to
think
another
during
person.
the tele-underwriter, when she called Mr. Ariano, I believe it was in Spanish, and I could be corrected, but I believe it was in Spanish. But the whole point of that conversation is, the cue into the conversation is, I'm here to talk about the insurance that you got with Donald. And you'll see in the transcript, he says, oh, no, 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 I didn't talk to Donald. And that was the inherent problem. And when I get to the bad faith issue, I guess if anything stuck in our craw, it was their refusal to acknowledge that because they forged his signature, instead of Donald following policy, meeting with Mr. Ariano, so Mr. Ariano would know who he is, they forge his name, it goes to the tele-underwriter, they call him up and say, hey, I'm here to talk about the insurance you got with Donald. He says, what are you talking about? No, no, no. They say, okay, fine. They stop processing the application. We pointed that out to them time after time after time after time. And they refused to acknowledge that their forgery led to the denial, number one, and their continued refusal to pay the benefits. And so when they say the forgery was not the basis for the punitive damages, that's true. But the bad faith was. And the bad faith was, read that transcript. And you know Donald didn't meet with him, even though his first deposition he came up with this huge story. He met with Mr. Ariano. No, he didn't. Came up with that huge story. They know that there was confusion, and they would never acknowledge that at all. Amen. I got sidetracked from the core issue. Would this have made a difference? I've talked about the lack of the offer of proof. How about the falsity of the two statements? In our view, this is very black and white. The first statement that they say was false. He denied having any symptoms of or being treated for any disease. Symptoms or treatment. And they say the EKG that he was never told about must be a symptom or treatment. Here's the testimony from Dr. Cifuentes, who they called at trial. And again, the question is, did they lie when he said he had no symptoms or treatment? Question, you never diagnosed Mr. Ariano with any heart disease? Answer, no, sir. Question, in the diagnostic test that was discussed, did you even mention that to Mr. Ariano? Answer, no, sir. Question, and why not? Answer, because we were talking about his general health and advice about what to do about his blood pressure and modifications of his lifestyle. Question, all right, so it was you're treating the high blood pressure and there's no other indication of any heart disease, fair to say? Answer, well, he had high cholesterol. Later on, question, did you actually examine him to see if he had any indications beyond the high blood pressure, whether he had any problems with his heart or heart disease? Answer, yes, we did. Question, what sort of exam did you do? Answer, physical exam. All right, and that was normal? Yes, except the blood pressure, high blood pressure. That's the examination a year before he files for the insurance. And he's supposed to put yes as to whether he had a symptom or treatment. And then they rely, and this is part of the bad faith. They say, well, the death certificate said he had arterial sclerosis, hardening the arteries. There's somebody in this courtroom who has heart disease. They don't know about it. And they know what the exclusion says, symptom or treatment. And they would consistently say, oh, well, he had hardening of the arteries. You question them, well, why do you think that's a symptom? When the doctor said he didn't have any. He came in, took a history, no symptoms. So that issue, in our view, is very black and white. only had the risk factor. There's a question about the admissibility of the EKG. You know, even the document itself said it was only a possible diagnosis that needed to be confirmed. They didn't bring in a witness who said, I looked at that EKG, that really is abnormal. They didn't even bother getting that witness. So we're going to send this case back to be retried with that being the single piece of evidence? I maintain to this day no defense attorney would even try and bring that in, because it would just give us another argument for bad faith. Let's go to the second question. Second question is, did your father die? Has a parent died prior to age 65 as a result of cardiovascular disease? 1 year before the application, when they said no history, 1 year before, when they see Dr. Cifuentes, and this is in the appendix tabs 9 and 12, October 2005, year before. Family history, heart disease, no history. Same day, family history, father, unknown. And they want to say they purposely lied when the next year they basically said the same thing that they did to Dr. Cifuentes? This is why they would never even try and bring that up at trial, because that's just more ammunition for us. How can you in good faith say that you're going to deny a claim when you had that information? And we repeatedly went back to them and said, why are you denying it on this basis? Then we get to the fact that the records that they want to rely on to prove that this was false is this statement in the hospital records where Mr. is taken after the heart attack. And I will point out, they actually never offered those exhibits in evidence. They don't have an offer of proof. And technically, they should have made an offer of proof and say, this is what we're going to prove. They didn't even do that. But let's set that aside. Here are the statements. One statement, father is deceased. He died of coronary artery disease. Let me start the first one. First one, father died from a heart attack when he was 60 years old. Second one, he died of coronary artery disease in his 60s, not 65, 60s. Third reference, father died of MI in his 60s. So does that mean 65? That's their best case. One reference that said at age 60, two that said in his 60s. And who's this statement from? I don't know. Maybe it's somebody that walked in off the street. We have no idea who made this statement. Would this jury even conclude, if they got all this evidence, oh yes, that really shows me that he lied about this? That would never would get in evidence. If you had a police accident report and the police officer put in there, unidentified witness saw the accident and says defendant ran the red light, that statement is never going to see the light of day in trial. That's this. That's what that is. Somebody who we have no idea who they are, how they came up with the information. Is it firsthand? Is it secondhand? Is it thirdhand? Is it made up? We're going to send the case back because they think the jury's going to believe that. And would the court ever sustain a verdict based on that evidence? The court would never do that. That's complete speculation. So we think it's very black and white. Just going to the brass tacks, the bottom line, never going to make a difference, not one bit of difference. And if you have to look at one single thing, it's they've got to have an offer of proof from somebody who says this policy would not have been issued if we had known this. They don't have that. If I could make a couple of comments about the application issue. One, if you look at that New Jersey case, the statute has the reference to when issued. The trial judge added the words and delivered, and it hadn't been delivered to him. The Court of Appeals said, well, you just added the and delivered words, which is true. Well, guess what our statute has? And delivered. That's the difference. And I wasn't exactly sure of the point they were making when they said we didn't address the point. The whole point of the whole application being attached to the policy, and if you read page 5 of their own application, by signing this, you're representing that everything's true and correct. When you get the application, you're going to read it and you're going to correct it. It's the same concept that's embodied. And Your Honor asked a good question. Shouldn't they be given the opportunity at that time to see if it's correct? They thought that was silly. Well, guess what? He got the date of birth wrong. He referenced that there was no physician. Those are obvious errors. And the legislature knows what happens. You go in, you're going to get insurance. The agent's over here, you're over there. And the agent says, ask some questions, and he writes it down. Oh, you had cancer 20 years ago? No, you didn't have cancer. They know that they're pushing to get the application through. They get paid on a commission basis. What do they care 2 years down the road? They know that. That's why they want the insured to have the opportunity to look at the application. Plain and simple. It's not that complicated. And again, the policy, the definition of policy says contract. The language talks about, in the statute, says policy or contract. I don't know what they're not seeing with the or contract language. Oral contracts for insurance exist.
Counsel, before we, giving your time in mind here, could you comment on the punitive damage issue, particularly as it relates to the ratio here?
I'm sorry?
Particularly as it relates to the ratio.
Well, here's my view, and it's not particularly, I guess this is the trial lawyer coming out at me. Supreme Court says, originally they say 9-1, then they come back and say, well, 4-1 might be approaching the issue. You go to a 1-1, let me just read the question that Ms. Rosen posed. Either we have punitive damages in the state of Arizona or we don't. This is not a deterrent. This is a carrot. Run the numbers on this case, $150,000 policy. Look at what they put us through. How many Rick Barrys in the world are there that take on this case, this time, this expense, and put up with all the ridiculousness? There has to be some deterrent effect to it. And in our view, absent upholding some ratio well above 1-to-1, it does nothing. In fact, it's not a deterrent, it's a carrot.
Counsel, do you have any authority supporting a 13-to-1 ratio?
13-to-1, Your Honor? No, other than the court's general statement that every case is going to be looked at independently. Now, there is the issue of whether you would consider the attorney's fees. I suppose in retrospect, if we had said, you know what, we're just going to make it an element of damage, we wouldn't even be here on that issue if the jury had awarded fees like the trial court. We don't think that that should make a difference when it comes to the constitutionality of what was awarded. That's a serendipitous result for them, that we decided to make the application post-trial under 12-341 as opposed to an element of damages, which I suppose in early years in the practice, that's what was done. I think convention is just that. This is what's done now. But we'd be at a 1-to-1 ratio if the court includes that. I do take issue with their contention that you don't look at the potential result. If punitive damage is all about having notice of the potential damages or the potential punishment you might get, in my mind, that says, before you hit that courtroom, with these facts, were you on notice that you might not get a good result? You bet they were. And they're rolling the dice, and they're rolling the dice that this court says, you know, we're just going to do 1-to-1 to 2-to-1, because that is a carrot. Let's take 1,000 of these policies. Why not just institute a policy? We're going to deny these. Maybe 10 out of 1,000 will contest it and go to trial. Those are the statistics. No deterring effect. I would reserve 2 minutes for the prejudgment interest issue. Thank you.
Your Honors, the final argument about institute this policy and do it 1,000 times, and if you only, That's completely inappropriate. There's no evidence in this record that of any conduct other than what occurred in this case. And that type of an argument that would justify the punitive damages is not appropriate under this, in the record in this case. I want to also mention that the concept that we're at the high end of reprehensibility. The high end of reprehensibility, according to this court's decision in Hudgens, is that it's either a physical assault, physical damage, which this case was not, or it's a situation where there's a disregard of the safety and health of the plaintiff. This case is that's the manufacturer who puts a defective product out there knowing that it's going to be killing and maiming people. That's at the high end of reprehensibility. At the low end, even if they're right, even if their jury-like argument were correct, then there's still that it was deceitful. That's still at the bottom half of the reprehensibility scale established by this court and supported by the U.S. Supreme Court. So that factor, that guidepost of reprehensibility is already in our favor. It's at the lower half. And then when you get to the ratio guidepost, there's no justification for 13-to-1 in this case. They try to make it justified by saying that we can add in these other non-compensatory damages for this bad faith and try to inflate that. Well, the case law doesn't support that. They also say, well, it's a small amount, and when there's a small compensatory damage award, the court does allow some flexibility. Well, all the cases that allow that are either $4,000, $5,000, in that range. The cases that are even less than $82,000, which was awarded here, all say that's substantial. You don't get to go above those kinds of ratios. In Nardelli, with this court's decision where the court took it down to 4-to-1, the trial court took it down to 4-to-1, this court said that's not enough to comply with the Constitution. And if that doesn't create deterrence, then that's a different issue. That's deterrence and punishment. That's Arizona state law. We're talking here about the United States constitutional right to due process. And those three guideposts all say that this punitive damage award was constitutionally excessive. Let me end by addressing the application issue. Even if this court were to say that statute does apply and agree with the trial court so that the applications themselves are inadmissible, how in a oral promise context where their whole case, but keep in mind for 4 years this case was litigated on the conditional receipt theory, and then right before trial they said, oh, by the way, the conditional receipt, which is part of the application and the whole application, those are inadmissible. So the rules changed in the 5th year of this litigation. But they say that the oral promise is their case. How can it be possible that you can sue someone on an oral promise and then, aside from the application itself, but the discussion about the application process, that what was orally said, that we're going to exclude that evidence as well? And we're going to exclude any evidence that supports the fact that we were not told the truth in that process. If the jury is going to be faced with the decision of, was Donald's testimony correct, that it wasn't unconditional, or Miriam's, that it was unconditional, they need to decide which of those things are true. And they don't have but half the evidence, because our witnesses weren't allowed to talk about what went on in terms of that, about that application, what questions were asked, what was told, and all of which goes to the reasonable expectation issue. So even if the statute could exclude the application itself, that document, that doesn't mean that the oral aspects of what went on. It would make sense if we were talking about the actual policy that never got issued, that application gets excluded, and you can't talk about those things. But when you're depending on a reasonable expectation theory of oral promise, it makes no sense to not allow the insurance company to even defend itself with respect to what occurred in that oral context. In terms of offers of proof, and we submitted this evidence in connection with the motions for summary judgment when we were litigating during the first 4 years. Those things are in the record. We don't need to, we're not allowed to, we don't need to go to the trial court and say during this second trial and say, we know you ruled, Your Honor, that we can't, all that evidence we can't admit, but here's what we would have said. We would have presented that same evidence. That's not required. And moreover, the concept that the whole probative value of what, Mr. Honorfree speculates what the jury would have done and would have not done. Well, your standard of review here is to presume that the excluded evidence would have had high probative value. You maximize the probative value.
Your time is up.
I appreciate your indulgence, and we would ask the court to reverse the judgment, and at a minimum.
Counsel, your time is up.
Thank you.
Thank you, Your Honor. Very briefly on the prejudgment.
Interest.
I'm sorry.
Just on the prejudgment interest.
Right.
Correct.
Prejudgment interest. The operative word in the statute is prejudgment interest for unliquidated future punitive or exemplary damages. Damages, not sanctions. I think that statute can be harmonized by realizing that probably what the statute is addressing is that when you get a verdict, an otherwise unliquidated claim is now liquidated. It takes some time to get a judgment. I've had cases where it takes 6 months to get the judgment. Statute says we're not going to give prejudgment interest on that. To the extent that there's a common law, which there is at least in other jurisdictions, I don't think Arizona's addressed it, that in the discretion of the court to compensate the plaintiff with an unliquidated claim, they may award it as an element of damage. That's what that addresses. This is a sanction. The prior cases make very clear when you're talking about a sanction, whether it's cost, interest, expert fees, those are just measures of the sanction. It is still the sanction. In fact, I would draw the court to the legislative history at the end of the statute. It says, quote, enacting a limit on the bond requirement to stay the execution of a judgment impacts the rights of appellants and is therefore a matter of substantive law that falls within the jurisdiction of the legislature. They didn't say that about the prejudgment interest on the unliquidated damages. And note that the Supreme Court, when this came out, changed Rule 7, the bond requirements, didn't touch Rule 68. And lastly, Division 2, in the Metzler case, if you go to paragraph 16, they know exactly that subsection D is there, and they make the distinction. Sanctions, this is damages. Thank you, Your Honor.
Thank you. Thank you, counsel, for your arguments. They've been most helpful. We will take the matter under advisement, issue an order in due course. We're going to adjourn briefly so that this group can leave and the next group can come up. Thank you.